Okay, welcome everybody to the Beverly Hills Bar Association's presentation of the Bankruptcy Jurisprudence of Justice William O. Douglas. We have, through the miracles of Zoom, we have speakers from all over the country. Judge Whitman Holt is with us from Yakima, Washington, and he will be introduced by Scott Bovitz. And those of you who have been to our other bankruptcy programs know that Scott does lots of programs. What I like to do, by the way, I am Robert Aronoff, the program chair for this program. And why I like doing these programs is that if my speakers don't show up, we have great resumes and I can just read them and fill the whole hour with them. But you receive them in your materials within an hour, and I believe there's a link in chat that you can download the materials, and the biographies of our speakers are there. Scott does great programs and did a great job of putting this program on. And he's been teaching now. He has two new teaching jobs that you should be aware of. He just started teaching as an adjunct professor at Cal Western School of Law in San Diego. And he continues a class this year at the William S. Boyd School of Law in Las Vegas. You also will be receiving your MCLA certificate shortly after the program. And please take a moment to complete the survey that is included with your certificate. And I think with that, be sure to look at the resumes in the materials, look at the advertisement about going to Scotland with the Beverly Hills Bar. If you've ever been on a Beverly Hills Bar trip, it's great. And with that, I'm going to turn it over to Scott to introduce our speaker. Scott?
I've been to Scotland, and if you're in Edinburgh and you have an opportunity, you should go to the Tattoo. Tattoo is a performance art that you will never find duplicated. Hundreds of bagpipes marching about and other things. Very, very amazing thing. When I was in college in the 70s, okay, I remember reading one of Justice Douglas's books. Now, it turned out I didn't realize he was quite as prolific as he actually is. And I've always thought, here's a guy who really knows where, he knows jurisprudence and he knows other things. And he was an environmentalist before it became a hip thing to be. And I remember him talking about plants and beautiful nature ought to have standing in court to represent itself. So flash forward to last October. It's the National Conference of Bankruptcy Judges, and I'm on staff and I'm interviewing some of our hip, fun judges about stuff. And Judge Holt, who's now the chief judge in Yakima U.S. Bankruptcy Court for the Eastern District of Washington, shows up and he sits down. Now, I know that he was a Los Angeles guy, even though he was born in Montana and he lived in a rural area and he went to Harvard. So he has, those two creds. He was at Klee, Touche, and Bogdanoff and Stern and Stutman, Treaster, and Glatt. And if you went to those firms, you were a made lawyer, if we could say that, use that phrase in connection with this. And then Ken Klee and Judge Holt, sorry, not Justice Holt, not yet, wrote a book on bankruptcy and Supreme Court, the whole shebang. And it was very interesting. And I kid Judge Holt because he's always quoting things from the 1800s Supreme Court cases that are absolutely on point. And so during this interview at NCBJ, Judge Holt started talking about Justice Douglas, and I realized that he's actually been doing a lot of research and analysis. Now, normally when I'm working with the Beverly Hills Bar Association, I give you a boring blocking and tackling program on evidence or writing declarations or federal rules of civil procedure or something. But I thought a conversation where I step back and we talk to Judge Holt about his research on Justice Douglas would be really kind of fun. So Judge Holt, talk to us about Justice Douglas.
Absolutely. Thank you, Scott. So we start with a.
I forgot one item. If you have questions during the thing, please put them in the question and answer. I will be monitoring that during the program. And I will, if we have time, I will ask those questions for you. Thank you.
Thanks, Bob. So we start with a very nice picture of Justice Douglas that Scott was able to track down. But before we get into the bankruptcy weeds, I think it's helpful to ask kind of who was Justice Douglas. And he had a nickname, sometimes used in a friendly fashion, sometimes used in a hostile fashion, as Wild Bill. It was Wild Bill Douglas of the Supreme Court. And there's a biography that a lot of the following information comes by that a guy named Bruce Murphy wrote, which is just a fascinating book. It's a very interesting examination of Wild Bill, who's quite a character. I think in the modern era, someone like this would never make it through the process and get appointed to the Supreme Court again. But it's also just a fascinating book with a lot of elements of United States history. So I recommend that, and I've used some of the points liberally in my presentation today. So Justice Douglas was born in Minnesota towards the end of the 1800s. He claims that he had childhood polio, although there's some significant doubt about this. Justice Douglas is kind of notorious, and we'll see another couple examples of this for telling tall tales. And some scholars and researchers have called into significant question his claim that he had childhood polio. He was certainly sick, but whether it was polio or not, we don't know. So he then moved to Yakima, Washington, where I now live, and grew up in Washington, being raised by a single mother. His dad passed away at a very young age, which I'm sure was difficult in the early 1900s. Justice Douglas's boyhood home is located in downtown Yakima, not too far away from my courthouse. So I wanted to go see his childhood house, and it's unfortunately been demolished. There's now a big concrete structure and a Safeway and a school. But there is a very nice memorial sign if anyone happens to be in Yakima. So he was valedictorian of his high school class. He attended Whitman College, which is a small liberal arts college.
Named after you?
No, not named after me. No relationship, although my wife did buy me a sweatshirt from Whitman College, which I'm not sure when it's the appropriate time to wear that, but I do have it. So then, like most of us, he decided he might as well go to law school. So he went to Columbia Law School in New York, graduating near the top of his class in 1925. And here we have another kind of tall tale from Justice Douglas, where he claimed that he was so poor after graduating from college and working briefly as a teacher in Yakima that he had to ride the rails from Washington to New York, by which he meant he was train hopping like a hobo, as they were called at the time.
Judge, I heard this is one of the rumors on the internet when you read this, that he was number 2 at Columbia. So I always want to know, and maybe someone in our group will put it in the room, who was number 1 in that class? That would be interesting to know. That's
a good question. I think it's in the book. Justice Douglas for a while claimed he was number 1, and I think that irritated the person who was actually number 1. Scholars, too, are dubious about this claim that he was riding the rails. Some people have actually dug very deep into the historical record and found train tickets that he used. You know, he took the train like most people by buying a ticket and sitting in the car, not by riding the rails in the fashion that he claimed. Justice Douglas then tried his hand at practicing law. He was at the Cravath, Swaine and Moore firm very briefly. Kind of at the time, that firm still had some residual railroad reorganization work, so he may have worked on some railroad reorganizations. He then came back to Yakima, and there's debate about whether he ever actually practiced law here. If he did, it was at most only for a month or two. So like many people who decide practicing law is not for them, he decided to move into academia, and he became a law professor at Columbia, and then his alma mater, and then moved to Yale Law School. And the Wild Bill book has a wonderful story about the back and forth that Justice Douglas and the dean of the University of Chicago Law School went through, where Chicago was trying to poach him from Yale. They ultimately didn't succeed, but there was a long saga. And Justice Douglas, the whole time, was very, very focused on how much he was getting paid. So there was kind of a financial bidding war back and forth between Chicago and Yale to try and get then Professor Douglas. And Justice Douglas doesn't come off looking, exactly favorable in terms of all the back and forth, at least presented in the book.
But he was a very well-respected professor at Yale. Someone said he may have been the finest professor of the time in the country. Now,
absolutely. Absolutely. So one of the things he did at Yale is he wrote a law review article. It's the factual study of bankruptcy administration, some suggestions, and you may recognize that second name, Jayhard Marshall. Jayhard Marshall was later involved in a dispute that had contributed mightily to bankruptcy law, and some were worried would destabilize the entire bankruptcy system. Scott, does that name sound familiar?
I don't know, but a blonde younger wife comes to mind of some kind. Penny Lynn Marshall, perhaps?
Yes, exactly. So Jayhard Marshall is the deceased Marshall that produced the entire Stern versus Marshall saga. So here in 1932, we have an article by someone who would contribute mightily to bankruptcy law through his work on the court, and then someone who would contribute mightily as a result of his dispute with his heirs' dispute with the Anna Nicole Smith bankruptcy estate.
You and I love history and going back in these little bits. I'm afraid that I put everybody in my bankruptcy class to sleep when I talked about the Code of Hammurabi. And it's forgiveness of debt if you sold yourself to the creditor for a few years and worked. Anyway, I think that's a wonderful tidbit.
Thank you, Scott. So Justice Douglas then was selected in 1934 to head up a study that the SEC was doing regarding the reorganizations of public companies at the time. That report was very opposed to the practice of the so-called protective committee. So the protective committee would be the large bondholders, the large creditors would get together, they'd form a group, often with the same investment bankers and law firms. And there was an argument at the time that really the little guy, the little bondholder, was getting thrown under the bus in order to grease the wheels of these repeat players in a process kind of reminiscent of what the legislative history to the 1978 code calls the bankruptcy ring. So the SEC report was very, very, very antagonistic to everything having to do with the protective committee process. And you still see this protective committee concept discussed today. Modern bankruptcy rule 2019, for example, and its requirement that security positions be disclosed in bankruptcy cases harkens back to the protective committees, that really there ought to be transparency. If you're purporting to be a group of bondholders speaking on behalf of everyone in the class, the court and the public generally ought to know what your positions are in the debtor securities. And you'll see commentary, law review articles, even case law about Rule 2019 that goes back and quotes materials dealing with these protective committees from the 20s and 30s. So then, after his report, Justice Douglas joined the SEC and then eventually ascended to be the chair of the SEC. During this time, Justice Douglas was a moving force behind a lot of the post-depression legal reforms. He advocated, helped draft the Trust Indenture Act of 1939, which is still the law today governing public bond indentures, including things like Section 316 of the TIA that deals with minority holders. Justice Douglas also really pushed and was intensely involved in the Chandler Act of 1938, which made significant changes to the bankruptcy law, including creating Chapter then X, dealing with public companies, where the SEC was very active, and the Chapter XI, which eventually was the precursor to what we all now know today as Chapter 11. So Justice Douglas really played a huge role in terms of the crafting those statutes. President Roosevelt then nominated Justice Douglas to the Supreme Court, ending his SEC chairship, and he became Justice Douglas when he was 40 years old, which is the third youngest justice in history.
Judge,
Scott?
I think that one of the rumors is that when he was called into the White House and told this, he didn't know what's going on, and he was afraid he was going to be appointed as the chair of the Federal Communications Commission, which I think is pretty cool job, and now is a very powerful position, but that's kind of fun. He didn't want that.
Yeah. So the whole nomination process, of course, is dramatically different from how it is today. So Justice Douglas holds many records from his time on the Supreme Court. He has the longest term that anyone in history has ever served on the Supreme Court. He was on the court for more than 36 years. That may get beaten, or Congress may adopt some of the proposals in the recent commission report and put term limits on Supreme Court justices, and Justice Douglas may hold that record forever. We'll have to see. He's written more opinions than any other Supreme Court justice. He's published more books than any other Supreme Court justice, more than 40 books in total. He wrote many articles, including several that were published in Playboy, which I think is kind of interesting. I mean, I can't imagine, Chief Justice Roberts or Justice Thomas today writing articles that show up in Playboy. I mean, it's just a different era. He gave a ton of speeches And one thing the Wild Bill book goes through is Justice Douglas was so prolific giving speeches and writing books because he needed money. Despite the fact that he was the bankruptcy guy on the Supreme Court, and despite the fact that he had a very healthy salary as a Supreme Court justice, he was always having financial problems, and he had to borrow money from other justices on the court. And he was taking on a lot of these side projects, like the books and the articles and the speeches, so that he could get paid because he was having such financial problems. Why was he having such financial problems?
Well, the final bullet.
Yes, the final bullet tells us part of the story, which he was married 4 times and divorced 3 times. And each time he got remarried, the age of the new wife got progressively younger and younger. So, and he inevitably, with the press of time, got older. So, in addition to his work on the court, Justice Douglas was actively involved in presidential politics. He was almost the nominee to be FDR's vice president in his last term instead of Harry Truman. And the Wild Bill book has many, many chapters on kind of the drama and the behind the scenes intrigue associated with who got that pick.
Was he first or second of the 2 people that was right on the list?
Yes, on the card. Yes.
And they reversed the card, for whatever reason. And there we go, President Truman.
And Justice Douglas considered running against President Truman when President Truman was up for a full term in 1948. President Truman had called Justice Douglas and asked if he wanted to run as his vice president. Justice Douglas declined, and his famous quote is, "I don't want to be the number 2 man to a number 2 man," was his famous line. Some say former circuit judge Richard Posner has written a law review article about this, about how the experiences Justice Douglas had with him not getting picked as vice president, not being the presidential nominee, kind of ruined the rest of his career. And Justice Douglas saw himself as kind of consigned to only being a Supreme Court justice, which he was disappointed with. And that after certainly from the 50s onward, he was kind of checked out from his work on the court. So that's at least some criticisms that have been raised about Justice Douglas. He greatly enjoyed travel. He had a second home up here in rural Washington. He extensively traveled to Asia and the Middle East in the 1950s. This contributes to some of the criticism that he was doing other things rather than his day job.
And it wasn't easy. You couldn't get on Japan Airlines and,
right,
live in luxury. You had to really work to get there and get around.
It was nicer though, Scott. Everyone wore suits and ties rather than Adidas tracksuits to the airport, at least. So.
I only have a suit. I don't wear anything else.
Yeah. So, and if you're ever in Yakima, Washington, there's a wonderful recreation of his Supreme Court chambers, including all of the alcohol bottles and all of his books and trophies from his safaris and everything else that's been recreated down to the letter. That's just a really, really cool thing to visit if you ever have a chance.
Who's in the William O. Douglas Federal Building in Yakima?
Not the bankruptcy court, but that's a long story for different times.
Okay.
So now we'll move to the Justice Douglas's bankruptcy decisions. So one of Justice Douglas's law clerks was a man named Vern Countryman, who later became a professor at Harvard Law School for many years and is the genesis of the famous Countryman test for determining what's an executory contract or not. Justice Douglas was notoriously hard on his law clerks. He worked his law clerks down to the bone. He was apparently a very demanding boss.
He called them the lowest level of life on earth or something, according
yes.
to one of them wrote a book. So
yes, yeah, he was not a good boss. But Vern Countryman, it's clear, has a lot of affection for his old boss, and he has particular affection for him in regard to his work in the bankruptcy law. And Vern Countryman, in an article dedicated to Justice Douglas, calls him the expositor of the bankruptcy law, and explains that Justice Douglas had a greater knowledge of the law and practice of bankruptcy than any justice who had preceded or any who has followed him. And here, 53 years later, that remains the case. I mean, certainly none of the current Supreme Court justices have any amount of experience or familiarity with bankruptcy that at all mirrors what Justice Douglas had.
Are you summarizing all the bankruptcy decisions since 1979 when you say that?
Well, I'm summarizing all the justices, so.
Okay, right.
So if we look at the numbers, Justice Douglas authored 38 opinions relating to bankruptcy law. 30 of those were majority opinions, with most of them unanimous. He wrote one 5-4 opinion, which we'll talk about in a little bit. He had one concurring opinion and 7 dissenting opinions, several of which were closely split 5-4 or 4-3 dissents, which we'll also cover in more detail later. So some of you may be thinking, well, wait a second, if this guy's such a big bankruptcy guy and so into bankruptcy decisions, like why haven't I ever heard of any of these cases? And in fact, you probably have. There are several very famous Justice Douglas decisions. We start with his first opinion, Case versus Los Angeles Lumber Products, which contains a very clear articulation. This is the famous articulation of the absolute priority rule that old equity doesn't get to participate unless unsecured creditors are getting paid in full. At the time,
I could give new value.
Yes. Well, maybe, at least right now, at least until the court addresses that again, you can. Importantly, the absolute priority rule under the Chandler Act was something individual creditors could assert. So even if the class as a whole voted yes, one or two dissenting creditors could stand on their rights under the absolute priority rule. So Congress changed that in 1978 on the grounds that that really impeded plans where, 95% or 2/3 of the class is on board with what's being proposed. The Case versus Los Angeles Lumber does reference the new value corollary. We don't know if the court ever takes this up again, if this is still valid. It's clear, though, that new value needs to be in money or money's worth that's reasonably equivalent to what old equity retains. So a host of intangibles or vague hopes or possibilities, the fact that the shareholder is going to keep working for the company, that's insufficient. It clearly needs to be money or money's worth. And I think that largely remains the law today. Another famous case I'm sure you've heard of, it's the last resort of scoundrels, is Pepper versus Linton, which is the Supreme Court's seminal bankruptcy case regarding equitable power, substance trumping form, collapsing steps in multiple transactions, really applying rigorous scrutiny against insiders of the debtor. We all know you can't have practiced bankruptcy law for very long without hearing about Pepper versus Linton. Some slightly less famous but still important cases that you still hear about today are Price versus Gurney. This stands for the clear bankruptcy proposition that, or the clear proposition that determining whether a bankruptcy petition has been validly filed is a matter of applicable non-bankruptcy law. So sometimes Chapter 11 petitions get filed by shareholders who don't have corporate authority. This is why with the petition, when a Chapter 11 case is filed, you need to attach the resolution authorizing the filing. That's why that rule exists, is because of Price versus Gurney, which is ultimately whether the petition was validly filed reduces to non-bankruptcy corporate law. Scott.
So if California says you can't file a petition unless the moon is in a certain part of the sky or whatever, and doesn't happen, I mean, they could effectively prohibit corporations from filing bankruptcy, couldn't they?
So there are some arguments that that sort of bankruptcy specific rule would be preempted by the bankruptcy code. This exists, but hasn't, I think, ever been litigated in connection with Chapter 9, where California has this pre-filing negotiation practice that needs to happen before a Chapter 9 petition has been properly filed. There's some argument that states can't legislate bankruptcy specific law. But certainly whether the board has had a meeting and approved it by the requisite number to file the petition, that's a clear question. And if you don't have valid board action, you're not authorized to act for the corporation for whatever reason, you can't file the petition. Cite Price versus Gurney, end of the day.
Right.
Another famous case, Gardner versus New Jersey, which is litigation where a bankruptcy trustee challenged the claim in lien of the state of New Jersey. The court is very clear, Justice Douglas made very clear that the claims allowance process is a fundamental part of the bankruptcy case. It's clearly part, we now call it today core, and even both statutorily and constitutionally core, if you want to use that lingo. The same thing with determination of the liens associated with the claims. That's also core in every sense of the word. And the court makes the point, which is still the law today, that when the government comes in, files a proof of claim, chooses to participate in the process, anything relating to allowance of that claim or determination of any associated lien, sovereign immunity goes away. It's waived through the act of filing the proof of claim. So very important.
And how could it be otherwise? Because the government's often a big creditor, and you got to resolve that quickly.
Absolutely. So then I thought it might make sense to kind of step back and look at some common themes in the Douglas opinions. And there are a lot. One common theme is Justice Douglas clearly believed in broad, expansive, uncodified, context-specific powers for the bankruptcy judge to get to the right result. particularly when it relates to claims or plans. That it supports equitable subordination, equitable disallowance, designation of votes, confirmation of plans just for bad faith because something suspicious is going on. And to me, the most unresolved and significant open question of modern bankruptcy law is, to what extent do the powers that are articulated in opinions like these still survive today when we have a Supreme Court, certainly, that's much more tethered to the statute. Justice Douglas had a vision where there's just a very, 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 very broad universe of bankruptcy, of uncodified equitable powers where the bankruptcy court can do basically anything based on the equities of the case. That, I think, has shrunk dramatically. And to me, there's a really difficult, hard question that I'll be curious if the court ever takes it, about what exactly can a bankruptcy court do that's not set forth in the statute. Things like substantive consolidation, things like recharacterization, where there's no statutory hook. Justice Douglas would have no problem upholding those things, but we live in a very different era. So it's a dramatic contrast to where we are today when the court's so driven by the text of the statute.
Judge Holt, when we say bankruptcy courts are court of equity, is that just a silly phrase that we say, or does that come out of this stuff?
It derives back to these things. There are modern Supreme Court opinions that say the same thing. There's certainly circuit opinions, Ninth Circuit and elsewhere, even recent opinions that say the same thing. The question really is, what does that mean? So you could say, well, this court's a court of equity. Clearly, Law versus Siegel makes express that doesn't allow me to rewrite the statute. That doesn't allow me to ignore the rules that Congress has set. To me, the big open question is kind of what to use a Justice Douglas phrase, what's in the penumbra? What's outside the statute where I'm not directly contravening the statute, so there's no Law versus Siegel problem, but I'm also doing something that grounding in the statute is difficult to, or maybe impossible to do.
You're gonna get to some statutory interpretation rules, but if you're thinking like Easterbrook from the Seventh Circuit, you're thinking, hey, whatever Congress does, we're gonna use at least most of the time, right? If that's right. We're gonna take that. We're not gonna fill in the gaps. This would seem to say, on some still okay Supreme Court case law, that no, you can go beyond that and maybe fill in those gaps when you need to. Is that where you're coming from?
Well, I think Justice Douglas would say even not just fill in the gaps, really, there's a whole hinterland of things you can cover that there is no gap in the statute because it's just the subject doesn't even appear in the statute. So if we're outside the statute, I think effectively Justice Douglas would say the bankruptcy court can just make things up based on the equities of the case to get it right.
105 is alive, right?
Yeah, 105 is very alive. Yeah,
okay.
Yeah. And again, today, I don't like it when someone comes into my court and the only thing they have is Section 105. But more common themes is we see a very, similarly with the power issue, Justice Douglas had a very expansive view of the nature of bankruptcy and the exclusive jurisdiction. There was no question when you look at the Justice Douglas opinions that if you have a competing state versus federal proceeding, or you have a regulatory agency that's involved in the bankruptcy court, Justice Douglas opinions make it very, very clear that the bankruptcy judge is in the driver's seat, that court has the paramount and exclusive jurisdiction, and competing courts, competing agencies, competing actors really have to come in second place to the bankruptcy judge. As a bankruptcy judge, I like these cases a lot. I think, again, it's an open question, the extent to which some of these survive under the modern code.
But you still have to take the trash out on Sunday because,
yes,
right.
Yeah. So another common theme, Justice Douglas, this is unsurprising, and I see my arrows have been replaced by squares on the screen. Those should be arrows. Unsurprisingly, given his work with the SEC, Justice Douglas was very, very, very negative regarding anything that was undisclosed or special side deals between the parties, and particularly when it related to estate professionals or other fiduciaries. These opinions often use searing language, and things like in Avon Park, there was a fiscal agent that had a conflicted role that resulted in complete designation of the votes. In Woods, there was a law firm that had a conflict of interest. All compensation denied, you get nothing, even if there was no injury to the estate. I mean, these are opinions where if you have a dispute about a professional or someone in a case who did something arguably wrong, pull up these cases because they set the bar extraordinarily high.
Judge,
Justice Douglas, oh, yes, Scott.
let me talk about that for a second. You know, in the modern big cases, in the Kirkland and Weil Gotchel and these things, their employment applications to me may not even show that they're not disinterested, right? They may have a conflict because they say things like, we don't think we represent any creditor group that's collectively owes more than, you know, has claims more than 5% of the creditor pool in this bankruptcy. Does that work given Justice Douglas's approach?
I think Justice Douglas would say no, that those firms are disqualified and can't represent the estate. I think the bar he sets is maybe unrealistically high, but it's much further than kind of contemporary practice. Not that I'm suggesting anything's wrong with contemporary practice, but I think he would be disapproving the employment applications of a lot of law firms in a lot of the large cases, I think, for better or for worse. Justice Douglas wrote several opinions dealing with the absolute priority rule that deals not only with the rule and the new value exception, but many of the other nuances. The Consolidated Rock case articulates a principle that my former partner, Ken Klee, wrote an article called The Uncodified Aspects that discuss the uncodified aspects of the absolute priority rule that survive today. One of them is the step-up principle, which a lot of people have never heard of. So what the step-up principle says is assume you have junior and senior, two bond issuances where you've got senior bonds and junior bonds. And the plan's going to restructure the bonds. And under the plan, everybody's going to get some portion of the new reorganized debtor securities. So new bonds, replacement notes on the other side of the case. What the step-up principle says is if you have someone who's senior, whether it's a senior bondholder or a creditor relative to equity, and they're getting new securities under the plan, there needs to be a step up in the value of the securities in order to compensate for the loss of seniority that's resulting through that restructuring. So it's not enough to say, well, first lien holders or senior bondholders, you're going to get 100 cents worth of replacement securities, and the juniors are going to get, 80 cents. You actually need to step the seniors up to 110 cents of their pre-petition claim in order to give them extra compensation reflecting the loss of seniority in their pre-bankruptcy securities. When I was still at Stutman, Isaac Petrulski and I wrote a brief on this in the Calpine bankruptcy where we unfortunately lost, but this is still a legitimate good principle and could come up in Chapter 11 cases where you have this step down in the nature of securities means you get a step up above and beyond the par amount of your claim. The opinions also have lengthy discussions of how to value replacement securities. The Chicago Railroad case was very important in the Second Circuit appeal in Momentive relating to whether the cram down interest rate needs to purely compensate the holders or not, whether you need to get replacement notes that trade at par on the other side of the bankruptcy. And Justice Douglas explained in that case, the valuation and the terms associated with the replacement notes don't need to be precisely set. It needs to be kind of roughly approximate, rough justice, not exact mathematical justice. So that supports bankruptcy courts using a cram down interest rate for replacement paper that may result in those replacement notes trading for less than par, and that's okay. Again, it's really, we're using ballparks, we're using ranges rather than exact mathematical amounts. There are several opinions Justice Douglas wrote. You should put all of these in your 9019 motions, and I'm working on an opinion in one of my Montana cases that will feature all three of these that should be out before the end of the month, where Justice Douglas is very encouraging of settlements and compromises. He makes clear these are part of the plan process, part of the bankruptcy process. It's something the judge generally should be encouraging. There's one opinion that talks about potential abuse of the settlement process, but generally the opinions are overwhelmingly pro-settlement. And again, Case versus Los Angeles Lumber, people think about it as an absolute priority rule case, but there's also a portion of it that's very clearly a settlement case, and that belongs in your 9019 motions.
9019 motions, you rarely see a big battle in connection with that. And when you do, the judge goes, I don't know, right? The lowest level of a range of reasonableness. That's a pretty wimpy standard. Should the standard be more crisp based on these cases?
No, I think Justice Douglas would be okay with that low standard. I mean, there's not an opinion that specifically addresses the standard, but his cases are very clear that we should be settling things, we should be compromising things. And that's, the way the system should run. There's many other familiar concepts that we'll recognize, right? The Wright case makes clear secured creditors have no constitutional claim beyond just the value of their property. It's not the face amount of the claim, you have to value the collateral. Valuation, as I mentioned, is not a mathematical exercise, it's context specific. One thing I saw in the comments, I think Sam Alberts asked what Justice Douglas would think about rights offerings. And there's an opinion called Mason versus Paradise Irrigation District. It was a chapter IX case, an old chapter 9 case. But the opinion says that if there's a member of a class that's providing something unique that the class as the whole is not providing, that that creditor doing something above and beyond can get an enhanced treatment, an extra distribution that's not necessarily going to the other class. So here, one of the creditors, one of the bondholders, I think it was a large public bondholder, was providing an exit facility or a new loan to the debtor that the other bondholders weren't able to provide. The plan provided enhanced treatment and additional consideration on account of the exit loan. Some of the other people said, wait a second, everyone in the class isn't getting this, and we can't provide it. And the Justice Douglas opinion says, well, that's okay. This is still nevertheless a confirmable plan because that particular creditor is doing something unique. That, I think, strongly supports the modern practice of we're doing rights offerings with backstop fees and other things in connection with the plan. They're technically not treatment of the claim under the plan. They're really consideration that's being provided for something that a subset of creditors is doing above and beyond what the rest of them are. And that Mason versus Paradise Irrigation District would directly support.
Judge, to go back one case with respect to valuation, is this a case I'd cite if I'm trying to get my judge not to just take expert A and expert B and split the difference on my valuation? I try and get a judge to think a little bit differently about that.
Yes, yeah, it would be a good case for that. And it would also be a good case if the other experts saying, well, look how poorly this business has done in the past. The Chicago Railroad case makes clear valuation needs to be forward-looking. It's projected earnings after the case. So the fact that this may have been a bad company that did poorly in the past, it's kind of like the old securities disclosure, right? Past performance is not indicative of future performance, right?
Yeah.
This makes very clearly that for purposes of valuing the debtor, valuing the reorganization securities feasibility, it's really forward-looking and not backward-looking. Finally, Justice Douglas, there are several opinions that repeat the familiar principle from the it's in the NLRB versus Bildisco case about when we're assuming executory contracts, they're assumed co-ownery, you're taking the entire contract. It also makes clear that if there's a contract that's bad for the debtor for whatever reason, the bankruptcy trustee doesn't just magically get to wave his hand and change the pre-petition contract. There's some more preferences for certain claims need to be clearly stated. Strong arm powers get conferred as of the petition date, not earlier in time. Generally, we shouldn't be awarding windfalls by reason of the happenstance of bankruptcy, which is a good quote you can use in different contexts. And finally, reorganization cases are intended to put back into operation a going concern. You want to stabilize cash flows and you want a business that can go out and stand on its own legs and walk around in the world again. And that's really an overarching principle of Chapter 11 today in at least some cases.
That's the feasibility explanation, right?
Yes, yes. So we have some principles of construction, construing statutes that a lot of these apply equally to the modern bankruptcy code. When Congress uses a word in the statute, it has the legal sense used when the statute was drafted. Emil versus Hanley saying the same thing that Mid-Atlantic, for example, said about the modern bankruptcy code, which is if Congress is going to make a major change to the bankruptcy law, it needs to be clear that's what they're doing. And if
wait, in 2005, did Congress really think about those many kind of weird changes that were like,
well, I'm not
pasted in like mud on a wall?
What Congress thinks about. So
Okay.
There are some at the bottom. The last bullet has some bizarrely constrained, unusually constrained for Justice Douglas quotes, where there being something in the statute, a clear expression of policy, the bankruptcy judge and even the Supreme Court is just bound to enforce the statute. You can't rewrite the statute to vest a power in the court that Congress did not plainly delegate. So that is in some significant tension to the otherwise very, very broad equitable powers we talked about earlier. But even Douglas had his limits.
this is a big area of debate here. You know, statutory construction, and it's not just the bankruptcy code, right? There are lots of codes that are integrated statutes of different kinds. How do you think about them? Do you think about them, well, you know, you're an umpire, it's a strike or a ball, and that's it, and you're done? Are you trying to affect the result? And I do think this last quote doesn't make any sense for Justice Douglas. I don't know why, he must have had a bad day or something.
Absolutely. I mean, I probably lean more to the Congress makes the rules and it's my job to be the umpire than some of my colleagues. But I mean, this is an active, you see this all the time with Baker Botts versus Asarco, for example, right? Where Justice Breyer's dissenting saying this rule doesn't make any sense. The Justice Thomas decision says, look, this is what the statute says. Congress makes the rules. If this is a bad rule, Congress needs to change it. So this whole dynamic is still very, very much alive, maybe even more alive today. One of my favorite statutory interpretation quotes is this quote about, we don't read the statutory words with the ease of a computer, which we all understand today, but you think back to 1966 and the fact that someone was talking about computers reading statutes.
It was the IBM 360 and punch cards. Okay.
Yeah, I mean, that's an amazingly prescient quote. And it's one I always think of. Sometimes I have parties before me arguing, oh, look at the statute. Here's the dictionary definition of word 1, word 2, word 3, and word 4. And you just line up those 4 dictionary definitions, and that's what the phrase means. And some things can be interpreted in that kind of very, very formalistic, almost wooden fashion. But often there's some context to the text as a whole that gets dropped out when we're doing this. I don't want to say plotting, but this very formalistic, we're going to dictionary define every single word and then just smush those definitions together. And that's what the text of the statute means.
And is it the word that it was defined as when the statute was enacted, you know, back yonder? Or is it something that's, you know, interpreted today in the Facebook, Google modern world?
Right. And that would be if all we're doing is lining up definitions and smushing them together. That's something a computer could do. And we don't read the words with the ease of the computer. So here's one I'll push this over to you, Scott. So here's a construction principle about how the bankruptcy law must be liberally construed to give the debtor the full measure of relief, lest its benefits be frittered away by narrow formalistic interpretations, which disregard the spirit of the law. You think that's still the law today? What's your view on that?
The only time I see this is when you're interpreting non-dischargeability and blocking the discharge, right? Because it's the discharge component, not the common creditor sharing of assets issue. And the judges say this, but I don't know what it means for you. How does that change the burden of proof? I think the answer is no, it's not good law.
Yeah, I tend to agree. I mean, I think this is a principle that the tie goes to the debtor, or really there's a thumb on the scale in favor of the debtor when we're looking at the statute. I think the modern court hasn't directly addressed this, but I think they'd say, no, we come in kind of blank slate, you know, no one gets a thumb on the scale one way or the other. But, you know, if you're representing the debtor and you're trying to do something that seems very unfair, you pull this out in the right judge, it could certainly help a lot. So it's not all rainbows and lollipops. There are some Justice Douglas decisions that are now clearly bad law. United States versus Randall, which is his only 5-4 bankruptcy opinion, the court held that unsegregated payroll taxes are not held in trust for the United States and belong to property and are property of the estate. Congress very clearly in 1978 repudiated that. And the Supreme Court has made clear that Randall's been statutorily abrogated. Now, trust fund taxes owing to the United States are held in trust whether or not they're segregated. The segregation doesn't determine the outcome. There's a case Justice Douglas wrote that enforced an ipso facto termination clause in an unexpired lease. The statute today now doesn't allow that to happen.
The case was good because it brought that issue to the attention of the draftspeople with respect to 365. And so it made it very easy to understand the issue.
Absolutely. There's another wonderful case. Justice Douglas actually dissented in this one, where the issue is what the damages are for rejection of a 999-year lease of real property. And the dispute, Justice Douglas dissented on the grounds that we need quantifiable damages. You can't have speculative damages, or the burden is on the party asserting damages to prove up and appropriately quantify their damages. And here the landlord hadn't done it. And how do you do it, 900 years into the future? This issue wouldn't come up today because today the cap in section 502b6 would cap the claim and we wouldn't get into nonsense about what's going to happen 900 years from now. We could talk some about some of the notable dissents. Reitz versus Mealy was a case about, so New York had a statute that suspended people's driver's licenses until their unpaid auto accident judgments are satisfied in full. Debtor filed bankruptcy and said, well, that's a dischargeable claim. I got my bankruptcy discharge. You continuing to suspend my driver's license because I haven't paid a dischargeable debt would infringe on my discharge. Another 5-4 decision. The majority of the court said, no, that's an enforceable law. Justice Douglas wrote a very forceful dissent. Justice Douglas ultimately won out here. Reitz versus Mealy was overruled by a case called Perez versus Campbell. And today we have Bankruptcy Code section 525, which makes it very clear that the failure to pay a dischargeable debt as a result of bankruptcy isn't a basis to withhold a driver's license or the other governmental benefits mentioned in section 525.
I think you're going to see Chicago eventually, after they work through all of the issues with respect to the not having to turn over the car, but there'll be some other decision saying that they have to give the car back to the debtor, turn over to the debtor, or truncated procedure. I think you'll say fine, but you have to have a sticker in order to be able to go downtown between 8 a.m. and 5 p.m. And you can't get a sticker if you have unpaid obligations. And, there's still some work here on that issue.
Absolutely. The St. Joe paper case is a great case. So here there was a Debtor Railroad, the Regional Rail Reorganization Authority, which was this government agency, was always involved in railroad reorganization cases and could actually propose and had to sign off on any plans. So the plan in this case was going to propose a forced merger of the Debtor Railroad with another railroad. And the debtor said, wait a second, we don't want to do this. Like, we're very opposed to this. We don't consent to this. Like, we object to this forced merger. So the question before the court was, well, does the bankruptcy statute authorize a non-consensual forced merger? Is there a merger mandate that the government can put in place? We might say, to put it into post-COVID terms. The Supreme Court rejected the mandate by a 4-3 majority, which I guess today was a 6-3 majority, and said that the bankruptcy law doesn't allow confirmation of such a plan over the debtor's objection, that you can't force a merger, you can't mandate a merger, you can't infringe the railroad's autonomy so as to merge it with another railroad. Justice Douglas dissented, and he has this vehement sentence, which he has the whole thing in italics in the original opinion, about how this effectively allows old management or stockholders, maybe out of the money equity, a veto power over the plan. So there's really an absolute priority rule problem where by allowing the debtor through the control of pre-petition management to block the mandate, to insist on the railroad's autonomy. Justice Douglas ultimately won out. Congress passed a mandate. Maybe they'll pass another mandate. We'll see what happens. Probably not in the Senate at least. But Justice Douglas was ultimately vindicated when Congress in 1978 added section 1123A5 big C, which expressly allows a plan to propose the consolidation or merger of the debtor with another entity. Once exclusivity is terminated, third parties can propose a plan, which means that plan can force a merger of the debtor on the debtor over the debtor's objection. And the legislative history, the House report that Professor Klee helped write, makes very, very clear that Congress affirmatively intended to legislatively overrule the St. Joe paper case.
And I'd like to point out that if Ken Klee wrote something as legislative history, it is the intent of Congress.
Yes, yes. Another famous dissent in a case that still remains good law today is Kaplan versus Marine Midland Bank. So the question in Kaplan is whether a bankruptcy trustee can assert claims belonging to individual creditors. So here the claims were claims against the indenture trustee under a bond issuance for malfeasance in connection with the debtor. The trustee said, I get to sue on behalf of the estate standing in the debtor's shoes. And guess what? It also makes sense for me to act as kind of an aggregator and assert claims on behalf of all the individual bondholders. 5-4 hotly split majority said the trustee lacks standing to belong to those claims. Those claims belong to the bondholders. Nothing in the bankruptcy statute puts those in the hands of the trustee. The trustee stands in the shoes of the debtor and assert debtor causes of action, but can't assert individual creditor claims.
Wait, is that the same? Sorry, go ahead.
Oh, Justice Douglas dissented and said, really making the kind of practical point that often these direct claims, particularly in the context where they're bondholders who only have, one right to a single satisfaction, these claims may affect what happens under the plan, and it really makes more sense to vest everything in the bankruptcy trustee so that he or she is in charge of all possible causes of action and can settle, compromise, restructure them as a whole under a plan. We see this sometimes today in modern liquidation trusts will take an assignment of individual creditor claims. So the litigation trust will take the estate claims, but there'll also be an opt-in mechanism or another mechanism for individual creditors to assign their claims to the trust, kind of solving this Kaplan problem. The problem it creates is there's some litigation in the Refco bankruptcy in New York that you had this problem of, well, are you acting as on behalf of the estate, or are you acting on behalf of creditors? And you see this whipsaw where you'd have a problem where whichever side the defendant could posture the claim is not being brought on behalf of, the plaintiff would lack standing and authority to do that in that capacity. So often this gets solved by these double-barreled liquidation trusts that are created under plans today. But this is still good law. Kaplan's never been changed. In some other context, for example, New York insurance law rejects Kaplan, but this is still good law, very much still good law today. Scott.
I was just going to give you a lead-in question for the insurance stuff. I don't understand that, but you hit it, so we're good.
Okay. The final dissent so this is an epic case, and I'm amazed we don't hear about this anymore. When I read this opinion, I candidly, until I read the case, I'd never really heard about any of this. I've learned something new. It's all slightly before I was born. But Congress in 1973 passed an act called the Regional Rail Reorganization Act, and it created this government entity called Conrail. And what Conrail did is it effectively sucked in railroad lines. So the actual physical railroad, the stations, the lines, the rights to travel lines, maybe even the railroad cars themselves into Conrail. And it sucked them out of several pending bankruptcy estates and several kind of distressed railroads. So you might think of this as the modern divisive merger or kind of good bank, bad bank, where you have existing railroads that are in trouble. The government took all the good assets out, leave all the garbage behind along with all the claims in the bankruptcy estates or in the now super distressed entities, which I think almost all of them inevitably filed bankruptcy, and took all of the good stuff and said, we're putting this in Conrail, and this is now a governmental run and controlled organization. So, and this is billions of dollars, even in 1974 dollars of assets. So there was substantial litigation about this. There was a takings clause argument that, look, this is the government just taking private property. There was also an argument based on the uniformity clause of the uniformity provision of the bankruptcy clause of the Constitution, which is now at issue in the U.S. trustee fee fight that the court granted cert on this week, where parties were arguing this is non-uniform bankruptcy law. This only affects railroads. You're not going and sucking all of the good stuff out of the liquor stores bankruptcy case or the clothing stores bankruptcy case. You're uniquely stripping and taking stuff out of the cupboard of the railroad cases. So Justice Douglas, this is his final bankruptcy-related opinion, wrote a truly epic dissent in which he would have found the act to be invalid both on takings grounds and on uniformity grounds. And there's just this quote, and the whole opinion, which is very long, sounds just like this. I mean, this is kind of the lead-in thing. But Justice Douglas says, if the rule of law under a moral order, so we're talking about the moral order as our measure of our responsibility, as he's always assumed, so this kind of Starkey aside, undertakes to sanction a fraudulent conveyance, there's a problem. And he says he's reluctant to conclude that's possible as it implicates Congress in a lawless maneuver of gigantic proportions, but baldly put, the present law, the RRRA, is a tour de force to that end. So, I mean, he thought clearly what Congress was doing was just going in to the detriment of all the creditors of these pending bankruptcy cases, stripping everything away, sticking it in Conrail. That's a taking, that's a non-uniform application of the bankruptcy law. And it's a massive, maybe adjusted for inflation, that may be one of the biggest fraudulent transfers of all time. So
it's Twine's case, but it's not sheep, right?
Yes, it's not sheep. It's
And that's a case from that era that's cited in BFP, right, in '84. So we know that it's still good law too.
that's right. So Justice Douglas lost out, probably for the good. Conrail's still around. I think it was acquired by, which is different from Amtrak. A big question I had was how much of this eventually became Amtrak, but they're actually two different things. But it is just a fascinating case. And again, this is something, all my years in practice, I'd never heard about this. I mean, I'd never heard about this as kind of a historical event. It maybe folks who are a little older than I and were alive at the time remember this. But it's an amazing fight. It's just an amazing, fun fight. I mean, Congress pushing the limits of what it can do. And it's a really fun dissent. I mean, it's fun to read just because of the vinegar laced throughout it.
The snarkiness.
Yes. So
I have a question on, as we're getting close to the end, we're not quite at the end. When Justice Douglas got to the end, he had some health problems, right? And he ultimately was convinced to resign his position, but he stayed around, hanging around, trying to write opinions and stuff on cases he had heard, and it caused quite a scandal. And eventually they took away his clerks and everything. It was a to-do. Do you have any comments on that? Kind of a,
well, it was kind of a sad end. I mean, there was a big discussion. I think President Nixon and then President Ford, a lot of people didn't like Justice Douglas for many reasons.
Ford especially.
Yeah, little of them having to do with his bankruptcy cases, but the environmental cases, the fact that he'd been around for so long, he was ornery, he was Wild Bill, as the phrase goes. And there was a significant effort underway to try and impeach him, which there have been judges who've been impeached. I'm not sure a justice has ever been impeached.
Yeah, well, I think you're right on that. And it never came anywhere. They would accuse him of things. They would conduct some investigation and it would go nowhere because there wasn't anything inappropriate that would be impeachable. Of course, I don't know what impeachment means anymore. You impeach everybody every day, it seems, but it just died. It was there. And Congressman Ford, later President Ford, was a man pushing one of those. So that was kind of interesting.
Very interesting. I mean, again, someone like this will never be on the modern Supreme Court, given, I mean, at the time he had the marriage issues. I mean, he was well known as a strong personality when he was at Yale and at the SEC. I think given the current selection process, we'll never again see a person like this appointed to the Supreme Court.
Look at Kevin. I had all the trouble with Beach Week, for gosh sakes, and that was really not much. So Bob Aronoff, we're going to turn it back over to you with great thanks to Judge Holt for his rapid fire review in connection with this. Take it away, Bob.
Okay, we have a couple questions in chat. First is, wait a minute, it just popped off my screen here a minute. I got the question, it's from Sam Albert, and he wants to know any thoughts on how Justice Douglas might assess rights offerings.
I did see that question. I think the Douglas opinions, to the extent we know anything from them, would, I think, be supportive of rights offerings under the Paradise Irrigation District case that I mentioned. That's on slide 20, or I think it's slide 22 because we put the bio pages in. Slide 22 of the materials that were sent out. So I think that would be approved.
Okay, and David Kupet asks, how does Price versus Gurney play out in a case where a lender imposes requirement for independent director and unanimous board approval for Chapter 11 filing, and then that director appointed by the lender does the lender's bidding by refusing to authorize a needed Chapter 11 filing? In the context where the lender required these requirements to be in governance documents.
Right. This is a bankruptcy proofing issue. Judge, go ahead.
Well, I mean, there's case on this. I think most courts uphold those. There are some, there was an opinion, I forget the name of it, out of Delaware that kind of allowed a workaround. I mean, I think the common thing you could do, we would do when I was in practice on the debtor side, is you send the fiduciary duty letter to the independent director and you say, if you don't authorize the filing, we're going to burn your house down and take your children. And and it'll be very bad. And usually they,
And legalese.
yeah, they either capitulate or resign. But I think if you have someone who, gets the threat letter and stands strong, and there's not something in applicable non-bankruptcy law that overrides that, I don't think bankruptcy law turns that off. That would be my view. Subject to, I reserve the right to decide this if I have a case raising the issue.
Yes, everything Judge Holt said today is not binding on him in his court. Don't quote it to him.
Okay, well, that ends the questions in chat. I want to give my personal thanks, and on behalf of the Beverly Hills Bar Associations, to both Judge Holt and Scott for an excellent program. And I think we are done and can sign off.
Thank you, everybody. Thank you, Judge. Thank you, Bob.
My pleasure. Take care. Stay safe.